Okay, thank you. Welcome. If everyone will join us, we'll have pledge of allegiance. Masha? I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. We'll have a roll call. Marsha?
Marshall McGonigal,
Louis Decker. Rex Mumford. Miranda.
Miranda Espiritu.
Thank you, Miranda, who is joining us on Zoom tonight. Thank you for those here. We only have this one item, regular agenda item BOA 25-8, request to appeal a decision by the Ogden Valley Planning Commission regarding the conditional use permit 2025-21, a request for approval of a CUP for a laydown yard situated on a property within the Mountain Valley -1 zone. The laydown yard is used by 1884 Line Company for Rocky Mountain Power work on the Eden Wildfire Mitigation Plan. And Tammy, you're doing the presentation tonight?
Correct.
Thank you.
Where this is an appeal, I don't have much of a presentation. I don't want to introduce any new information into the record. And so what is included in your staff report, you have the appellant's narrative and what they're basing their appeal on. I did state some of this in here. This is a laydown yard located in the Manufacturing Valley 1 zone in Ogden Valley. The appellant is appealing the fact that the applicant for the conditional use permit was out of compliance for a bit. They're stating some deficiencies in the staff report. You have his narrative in there. So what's included is the applicant's narrative and the basis for their appeal, as well as the staff report for the conditional use permit and the draft minutes from that planning commission meeting where that conditional use permit was approved. That's all I've got for you. So again, I don't want to introduce any new information inadvertently.
That's perfectly fine.
Okay.
Tammy, while you're there and Rick or Director Grover, if I could just get some clarification for us as a Board of Adjustment on a couple of these items. So we've read through the packet. We've actually had the opportunity to have it for a while. On Tammy or Rick, on October 28th, the land use authority at that time was the Ogden Valley Planning Commission. Is that correct?
Yes.
And the land use authority, do they have the authority to issue CUPs?
They do. So a conditional use is actually a use that is permitted in that zone with certain conditions to help mitigate any potential nuisances. But it is a permitted use in that zone.
Okay. Because we've seen this in our packet. Is there anything, and I don't know, are CUPs, is it by ordinance or statute? Where's the authority?
So CUPs are governed by the use of that zone that it's located in. So in that specific zone, there's certain uses that are permitted and there's certain uses that are conditional. Those conditional uses are uses that would be allowed in that zone with conditions. Based upon state code, it's very difficult to deny a conditional use permit. The only reasons that you could deny conditional use permits is if you can't put reasonable conditions upon that use to make it compatible in that zone. To kind of give you an idea of what some of those unreasonable conditions might be, is if you couldn't provide life safety issues, that impact the life safety of an individual. But typically you just place conditions upon those uses to make those uses compatible with the area.
Thank you. Because we've read it in the narrative, if someone's not in compliance, and in this particular case, not having a CUP, but any non-compliance, what's the county's position typically?
Typically, we we have a code enforcement division. And unfortunately, we only have 2 code enforcement officers. And so our code enforcement in the county is not, unfortunately, as proactive as we would like. It's more reactive. So when we find out that there's a violation, we work on bringing them into compliance. I wish we were able to have more code enforcement officers in the county, and then we could be more proactive. But unfortunately, in most municipalities, they have 1 or 2 code enforcement officers, and so it becomes more of a reactionary type enforcement.
Okay, so if someone, as in this particular case, is not in compliance, is there anything in the state code or statutes that would not allow the land use authority to issue a CUP?
No, as long as they are within the rights of that use, we're obligated to bring, in this situation, bring them into compliance. That's what we're always trying to do with most individuals that may not be in compliance, is we always want to try to bring them into compliance so that they can integrate into the community. And those uses that are specified are uses that were approved legislatively, and those permitted and conditional uses were approved by the legislative body, in this situation, the county commission, and they deemed that this specific type of use is a conditional use. It's not a permitted use, but it's a conditional use with conditions.
Okay. If someone is not been in compliance for an extended period of time, does that have any bearing on issuing the CUP and the term for the new CUP that is issued?
It could be, if the planning commission chose to make that a condition. Say, for instance, if there were certain penalties or things like that that needed to be taken care of, to have them come into compliance with those prior to the issuance of conditional use permit. In this situation, there was none of those, and so the planning commission approved it with the conditions that you have in your packet.
And I think also in our packet, there was, at least I interpreted, was some question about the term that was granted by the land use authority. I believe they authorized 17 months of conditional use permit. Is it a typical 17-month? Is that the normal time frame?
That's specified with this specific use, is those requirements.
Okay, so 17 months is not out of the ordinary for this particular use.
Typically, conditional use permits, if you just look at them, if there's not special provisions, this one had special provisions that could allow for that, but typically they're valid for 12 months.
Okay, so this one was authorized for, I believe, 17 months, is that correct?
Correct.
16 months. So they granted that extra period of time.
And sorry, can I jump in? So conditional use permits, you have 12 months to act on them. They run with the land until the use changes, is abandoned or expanded. Does that sound right?
Okay.
So typically, this CUP would be in place for however long until the use stopped or they wanted to change the use. Planning Commission was very specific about the time on this because they felt, given the nature of the work, it made more sense to put a timeline on it.
Good, thank you. And this particular decision of notice listed 6 points that we have here. And obviously enforcement of these conditions has nothing to do with this board. This board strictly looks at whether or not the condition, in their case, whether or not the conditional use permit was issued properly.
That is correct.
Or authorized properly.
That is correct. The conditions are that are specified here, that would be upon if they're not satisfied, what would happen is we would take that back to the planning commission and look at revoking the conditional use permit if certain conditions weren't adhered to.
And code enforcement would be the ones that would bring that to your attention, is that?
Typically, or if the residents have indicated that, then we go out and check. There was some conditions that were mentioned as far as on this one, as far as I think there was some dust mitigation. But our code enforcement officer went out and looked at it and they found everything to be in compliance. And I think there was some things about dark sky and our code enforcement officers went out and looked at it. And they found it to be in compliance. Okay. So that's what I can report at this juncture.
Appreciate your helping us to understand this particular, because we don't normally deal with CPs, obviously. So thank you. Tammy, unless you have something else, we'll invite our appellant to come up and you can state your name and your address if you would, sir.
Chair, while the applicant's coming up, I did receive this handout for the board members. You are not allowed to take on new information on the case. So our legal department and myself would advise you that not to take on any new information because you're only allowed to review what is currently before you in the packet. Correct.
Are we okay to have our appellant addresses?
Definitely.
Okay.
Yeah, we would definitely encourage that.
Since we've had him come to the.
Yes, please.
So let's go to the evening Christmas Eve.
Thank you. You wanna share with us your name?
You bet, Chair and members of the board. Thanks, like I said, for coming out for a second time, and it happens to be on the evening Christmas Eve, and it's sort of planned. My name is Christopher Cross. I own a small business immediately adjacent to the site subject to this appeal, which is conditional use permit 2025-21. I want to begin by making your task tonight as clear and straightforward as possible. You're not being asked to rehear the application. You're not being asked to weigh public opinion. You're being asked a much narrower question. Did the Planning Commission correctly apply the land use code? And is the approval supported by substantial evidence in the record? I believe the answer to both is no, and I want to explain why in a very structured way. First, the code framework, the rules of the road. A temporary construction laydown yard in the MV1 zone is not by right use, is not a by right use. It is a conditional use, which means approval is required before the use operates, not after. There is no provision in the code that allows a conditional use to operate for a year without approval and then apply retroactively once that year has passed. That interpretation that a year of operation is allowed before a conditional use permit is required appears repeatedly in the staff report and staff explanations, but it is not in the code. This matters because the commission's approval rests on that assumption. Second, duration. The approval exceeds the code. The code limits temporary uses like this to a defined time period. Here, the commission approved a 16-month conditional use, not because the code allows it, but because it is how long the project will take. Project convenience is not a code standard. If the code allows a maximum of 12 months, then approving a 16-month requires clear legal authority and specific findings explaining why that limit can be exceeded. Those findings do not exist in the record. Third, the evidentiary record, what staff did not do. Even setting the code issues aside, the approval must still be supported by substantial evidence. Here, staff recommended approval without doing basic due diligence. The operation had already been active for approximately 17 months. That gave the county an unusual advantage, real world data. Staff could have contacted the surrounding existing businesses and asked a simple question. Have the standards actually been met in practice? This did not happen. Instead, the staff report relies heavily on assumptions and applicant descriptions, and it contains factual inaccuracies about the conditions on the ground, including fencing, site security, and the absence of neighbor impacts. These inaccuracies matter because they go directly to the conditional use standards relating to safety, compatibility, traffic, and nuisance impacts. Fourth, why this matters. This appeal is not about whether the project is important or whether the applicant is acting in good faith. It is about whether the county applied its own rules evenly and based its decision on verified facts. When the conditional use operates for 17 months without approval and then receives an extended approval based on an incomplete and inaccurate record, that undermines the confidence in the code itself, especially for small existing businesses that complied from the beginning. Requested outcome. For these reasons, I am asking the board to vacate the Planning Commission's approval of conditional use permit 2025-21. The errors here go to the foundation of the decision, incorrect code interpretation, and a deficient factual record, and they cannot be cured simply by adding conditions after the fact. Thank you for your time, and I do have printed copies of my comments if it's easier to follow along on paper. I think since I've said them already, I think that can be included in the record. Is that true?
Our legal department and us say no. You're able to give your voice comments, but that's it. Thank you.
Thank you for the.
There's a lot there. Thank you.
Okay, Director, is it, in the particular case of an appeal like this, is it appropriate to ask for the property owner, you, the CP holder, to list the board if they desire?
You could, if you so chose, because it would be fair to give them an opportunity to speak, unless legal feels different.
I agree.
Yeah, okay. So would you like to come forward?
Yes, please.
And again, we appreciate you showing up again, second week in a row. Both of you, thank you.
Do you mind an address as well?
Yes, please.
Okay, Victoria Garcia, 1824 LineCo. I'm located at 9785 South Monroe Street, Sandy. Thank you, Board of Adjustments. We appreciate the opportunity to respond to Mr. Cross's appeal concerning the issuance of 1824 LineCo's conditional use permit. First, I want to acknowledge the frustrations outlined in the appeal packet. We actually share many of those frustrations, and we do understand the concerns related to the day-to-day operations of a construction laydown yard, and have taken significant steps to mitigate these impacts. These steps were implemented immediately following the issuance of our conditional use permit and include turning off our crime deterrent lights, including security cameras, turning off our job trailer floodlights, increased frequency of street sweeping at construction entrances and watering yard when temperatures required, yard and neighboring lot were thoroughly cleaned of any trash and construction debris, and aggregate stockpiles were reduced, and intrusive barrier containment was installed to prevent materials from encroaching on the neighbor's property. The appeal packet suggests particular frustration that our yard operated for several months without a conditional use permit. We do share that frustration. I want to just provide some context on how that was discovered. On September 9th, an agent from Weber County left a letter stating that our yard needed a conditional use permit. It said they tried to contact the property owner several times, but they weren't able to, so they came by and left the letter. In this letter, it does state that due to the yard being in operation for longer than 12 months, we now require a conditional use permit. Same day at about 3 p.m., I called code enforcement just to see what we could do about the notice, what the next steps were. And they did tell us we needed to obtain this permit and to submit that application, which shows sign of good faith. They also stated that their initial reason for looking into the yard was due to receiving complaints from the business's neighboring yard. The complaints were due to the alleged asphalt and dust in the street that tracked that issue, as well as cars speeding on the road. So after that, we did go through our records and found a comment from the Weber County Planning Division when we had asked before we moved in if we would need that permit. And they stated a conditional use permit is not warranted for the scope of work. The laydown yard near the north area will not require a conditional use permit because of its temporary nature. That note was left in June 2024. It did not state anything about the 12-month requirement. So next morning, I personally went to the Weber County Planning Division, let them know about the letter, asked again how we could be in compliance, and they stated they were also unaware of that 12-month rule and did not know we needed that permit. At that point, they said that they felt the conditional use permit was excessive for our use and that they would discuss amongst themselves to see if what they could do and if we would need that application. But again, we need time to submit the application. So that was submitted the same day. And then morning of September 12th, they called me saying that they did want to, do the whole hearing process for the conditional use permit, but in the meantime, we could continue to operate until that decision was issued. I did get another email back saying they weren't sure to call code enforcement. I called, did not receive a response. We also called a few times asking for copies of the complaints, which we never received. So as you can see, we made every effort to ensure compliance once it was discovered that that permit was required. Again, at no time were we ever provided copies of those complaints, nor were we informed of those complaints being made by our neighbors. In regards to the complaints surrounding dust control, we have been sweeping regularly. We do have a daily log showing those sweeping efforts. And we do think it's worth noting that there are 2 other contractors on this street who have aggregate and construction companies, and neither of them appear to maintain the dust or track out. So our efforts are kind of cleaning up for the neighboring businesses. But these issues can't be attributed solely to our operation. So finally, we'd like to remind the board that our yard is located in one of the few designated manufacturing zones in the heating liberty area. These zones exist precisely to accommodate operations like ours, and maintaining their intended use is critical for supporting infrastructure projects that benefit the broader communities, such as the wildfire mitigation efforts we are working on to protect the community from increased wildfire risk. Again, we understand that there are some challenges sharing a manufacturing zone, but we respectfully request the board uphold our conditional use permit. And just ask that you take into consideration that the requested relief from the applicant seems to be punitive towards our business. And we have tried every effort to make sure we're in compliance.
Victor, just stay put for a second.
Yeah.
Directors, do you have any comments about some of her comments?
As far as the first few months, the code does allow them to operate without a conditional use permit. If they do go beyond that, then they do need to get a conditional use.
Okay, so what she's saying is correct in terms of that was all right initially.
Yeah, there is a period of time where they can operate, but if they exceed that, then they do need the conditional use permit.
Is there a time frame on
I
that?
believe it was 6 months that they have where they can operate. I don't have it right up in front of me, but I believe that's the period of time. And then if they exceed that, then they do need the conditional use permit.
And so the party sets up their property, their manufacturing or whatever it is they're doing, and they're good for 6 months or a period of time at
It's
least.
only this specific type of use.
Okay.
Yeah, most conditional uses, they have to get those before they can operate.
So in this particular case, they were okay for the first little bit.
Correct. And then, once they exceeded that, then they were not.
Okay.
And typically, our code enforcement department doesn't release information on complaints and things like that. And also in case it goes to court, things like that.
And Mrs. Garcia stated also that she never received some of these notices that they requested. Is that again the same reasoning?
I don't know on that. I don't have that information.
How about her comment of coming to planning and being told that you don't need a CUP?
I would have a hard time feeling that our code enforcement officer would say that because she's been with the county she's getting ready to retire in March. So she's very knowledgeable of the code, but that's not what I have historically seen from Ms. Head.
If it's helpful, I do have the name of them who even told us that they weren't aware of that code, and I also have the comment where they told us we didn't need a permit. It's actually in the permit application portal. Is where we have requested it through.
And that could have been for the 6 months, but when you go over the 6 months, then you do need the permit.
Okay.
So there may have been, some of that information is true, but once you go over that period, then you do need that actual permit.
Do you have any questions?
I actually have a question for Lauren. If you remember an email, I sent her a couple. When we first were gonna review these, was it 12 months they're allotted to operate without the CUP, or is it 6?
My understanding is, makes sense.
And, yeah, 12 months it is, so.
So they were fined for that first 12 months.
Yeah.
And it was after they exceeded that code enforcement then said you need to. Or approach them that they needed to get a CP.
Yeah, and typically we don't, like I said, we're more of a reactive code enforcement department, unfortunately, so. If, we're not told that they're in violation, sometimes we don't have that triggering mechanism to follow up. I'm not saying that's right, but I'm just saying that's how historically, it has been.
Do you have any? Thank you very much. Miranda, I skipped you a little bit. Did you have any comments?
I'm curious as to when operations started. Some of the comments from the one lady I couldn't quite understand over Zoom. So I really am curious when operations started.
Yeah, we started in June 24, and that's
You're going to come back up with something. That way you'll be on the record.
We started in June or July of 2024. I can look at our lease and provide that if we need to. And then the request for information regarding the conditional use permit was also sent in June of 2024.
Okay, thank you. Miranda, anything else?
Did she say that the application was made in June of 2024?
I think that was when the business started, was June of 24, June or July of 24. And then the application for the CUP would have been filed sometime in 25, probably late summer or early fall,
In excess of the 12 months?
based on what we had in front of us.
Okay.
Probably after that 12-month period.
Thank you.
Thank you. Okay. Discussion. To me, the key to this is the land use authority operate within their authority to issue the CP. That's what's being appealed, is that they operated. I don't know if I want to use words into their mouth, inappropriately or not properly. So, discussion. Louis, do you want to share a thought?
You two are gonna love my thought. I was actually thinking about making a motion to move into a closed session to further discuss.
We can do that. Is there a second?
I'll second the motion.
Okay. We will adjourn to,
Do the vote on the motion.
oh, sorry. All in favor, vote. Aye. And chair vote aye. Okay,
Aye.
we'll move to a closed session for a few minutes and then we'll return. Okay. Is there a motion?
All right, I'll make the motion to close the closed session and reconvene and open the public meeting.
Second the motion.
Okay, all in favor?
Aye.
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 Thank you. We're back open session. Okay, after deliberating, is there a motion?
Chair, I'll make a motion to uphold the decision reached by the land use authority as they did not err in their decision to issue a conditional use permit. This is based on the fact that the land use authority and board of adjustments do not have jurisdiction over code enforcement issues. And the land use authority appropriately applied the mitigating factors for issuance of this conditional use permit.
Okay, so there's been a motion. Is there a second?
Second.
And second by Miranda. Any discussion? A call for a vote by individuals. Miranda,
Aye.
Marshall,
Aye.
Lewis,
Aye.
chair will vote aye. Okay. Any other business tonight, Director?
We are trying to plan the dinner for the appreciation for you guys and the planning commission. We were looking at the end of February or the end of January. Do you have any conflicts with those times of the month? Like, can you give me the specific dates we're thinking about? It would be January 29th or February 26th.
Are you wanting feedback?
Yeah, and you don't have to give it to me now, but we did. Okay.
Of February, how about 29th of January? Is that what you said?
Yeah, 29th or February.
I'm fine with 29th of January.
Okay. And we're getting feedback from the planning commission as well, so we'll, I can't guarantee that, but, I would get those.
And as long as we bring the birthday cake, I'm okay with the 26th of February.
Yeah, I don't think, Lewis is.
Oh, I don't care.
Totally get it, so, yeah.
All right, thank you.
That's all I have.
All right, Lauren, anything else from Lee? Okay, is there a motion to adjourn?
I'll make the motion to adjourn.
Second?
I'll second.
Okay, all in favor?
Aye.
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 Fine. Thank you for coming tonight.